Secretary of State for the Home Department versus Franco Vomero, Italy.
Lord Reid will explain the decision of the court.
This appeal concerns the rights of EU citizens living in the UK under the EU Citizens Directive and the UK legislation giving effect to it, and in particular, the protection which they are given against expulsion if they commit criminal offences. The appellant, Mr. Vomero, is an Italian citizen who came to live in the UK in 1985. He committed a number of relatively minor offences and served some short periods of imprisonment. Then in 2001, killed another man. He was convicted of manslaughter and sentenced to 8 years imprisonment. He spent the period from 2001 to 2006 serving the custodial part of that sentence. The Home Secretary decided in 2007 that he should be deported. Since then, he's served some further short sentences of imprisonment during 2012. Mr. Vomero challenged the decision to deport him, relying on rights conferred by the EU Citizens Directive. The directive provides EU citizens with 3 levels of protection against deportation. The level of protection which applies to a particular individual depends principally on how long he or she has resided in the host country. The directive is far from clear in many respects, and the progress of these proceedings has been repeatedly delayed as successive cases, including this case, have been referred to the European Court of Justice in order for the meaning of the directive to be clarified. Mr. Vomero argued that he qualified for the highest level of protection against deportation at the time when the decision was taken, and that the decision was invalid because the requirements that have to be met before someone in that category can be deported were not met in his case. The directive states that the highest level of protection applies where the EU citizen has resided in the host country for the previous 10 years. The Court of Appeal accepted Mr. Vomero's argument, since by the time of the deportation decision, he'd been living in the UK for more than 20 years. The Home Secretary appealed to the Supreme Court on the basis that in order to qualify for the highest level of protection, the EU citizen must first have qualified for the lower levels of protection, although that's not stated in the directive. In order to qualify for the intermediate level of protection, the EU citizen had to have a right of permanent residence in the UK, and the Home Secretary argued that Mr. Vomero had not acquired such a right by the time of the deportation decision. That was because a person can qualify for a right of permanent residence only after 5 years continuous legal residence in the UK, and the Home Secretary argued that Mr. Vomero did not meet that requirement at the time of the deportation decision because he'd been serving a sentence of imprisonment for all but 9 months of the period from when the directive came into force in 2006 until the deportation decision was made in 2007. The Supreme Court allows the Home Secretary's appeal. In the light of the European Court of Justice's ruling on a question which this court referred to it, it's now clear that before a person can qualify for the highest level of protection against deportation, he must first have met the requirements for the lower levels of protection. The Supreme Court holds that Mr. Vomero did not have a right of permanent residence as at the date of the decision to deport him, and therefore did not qualify for the intermediate level of protection, let alone for the highest level. Although he had completed more than 5 years continuous legal residence in the UK before his imprisonment, that period of residence did not qualify him for a right of permanent residence at that time because it was completed before the directive was due to be implemented in the law of the UK. Nor did Mr. Vomero qualify for a right of permanent residence when the directive was implemented, because his 5 years continuous residence before that date had been followed by more than 2 years imprisonment, which meant that the 5 years could not start running until he completed the custodial part of his sentence. That remained the position in 2007 when the deportation decision was made, as less than 5 years had elapsed since he completed the custodial part of his sentence. It will now be necessary for the case to be considered again by the relevant tribunal, as there has not yet been any assessment of whether the basic level of protection against deportation for which Mr. Vomero undoubtedly qualifies, is sufficient to protect him from deportation in the circumstances of this case. The Home Secretary also accepts that it's open to Mr. Vomero to argue before the tribunal that he has become entitled to a right of permanent residence during the period since the deportation decision was made, 12 years ago. If he can establish that he now qualifies for a right of permanent residence, the tribunal will have to consider the implications of that under the directive.